Good morning, dear students. I hope that all of you are doing well and safe and healthy. Thank you very much for our previous discussion where we have talked about the scope of application of international humanitarian law, in which situations the law of armed conflict should apply or does apply. We talked about some important key legal sources of international humanitarian law, including the so-called Hague Law Group and Geneva Law Group. Today we have reached the topic of the so-called status of combatants in the law act, the law of armed conflict, or IHL, and their protection. So we are going to dedicate the next 20 minutes to the discussion of legal issues that are pertaining to the determination of their status, as well as revealing some problematic, challenging questions that are related to according or affording legal protection under IHL to the so-called lawful and unlawful combatants. Let us move to the next slide. Before we do that, I would like to remind you about a couple of key issues that we'll have to constantly return to or keep in mind when we're talking about such a specific question as the status of combatants. First of all, I would like to remind you about a brief definition of international humanitarian law. We won't be dealing with the detailed one, which we have discussed a couple of sessions before. It's enough, it suffices today just to cover, just to remind ourselves that international humanitarian law, or IHL, as we know it, represents a group or a system or set of legal rules which seek, for humanitarian reasons and purposes, seek and try to limit the negative humanitarian consequences that are brought by armed conflicts. There have been several denominations or titles for this corpus of legal rules, which are used as synonymic to what we know as international humanitarian law. Many of you may recall the so-called resonating ius in bello term, which translated literally from Latin would mean the law in war. And that's a very popular term in use by international lawyers and scholars when they would like to designate the legal rules proper, which should be applied precisely during armed conflict. But very often nowadays there is another modern term that is also used to describe international humanitarian law, and that would be the so-called LOAC, or the law of armed conflict proper. This is also a very key legal term, rather specific term, and there is yet another third designation for IHL, which is usually used by people who are not so familiar with legal implications, meanings, designations pertaining to this important branch of international law. And that would be the law of war. And here I would like to remind you the distinction between the meaning of the war and armed conflict. War has been used in a general sense to describe the situation when there is a use of armed violence, use of armed force, to cover multiple situations of human conduct when nations, peoples, states and non-state actors, they are involved in fighting against one another. But there is another more precise term, which is armed conflict, and that would be the one that we'll be constantly using and have been using in our course, and that would be armed conflict, which is a more specific, more concrete legal terminology that more concretely describes the conduct of actors or belligerents in a wartime situation. That also refers to the use of armed force by the term armed, and it also more precisely denotes this situation as a conflict. So armed conflict would be the preferred, more precise term that we'll be using instead of war. But of course, let us keep in mind that when we refer to the Geneva Conventions and many other important treaties and legal sources containing rules of IHL, those sources themselves, because they are old enough already to be referred to as having a long history, they contain also in their titles the term war. Like the famous Geneva Conventions of 1949 on the protection of victims of war. I would like to also very quickly, very briefly, to remind you about the so-called main purposes of IHL. There are basically two of them. The first one, if we are using this short definition that I told you about before, is to spare those persons who are not participating in hostilities, directly participating in hostilities, or no longer participating directly in hostilities. That's the first main purpose of it. And the second one is to restrict the use of armed force to the bare minimum necessary use of it, only enough or sufficient to reach the precise military objectives, not for any other purposes. So these are the two key purposes of IHL, as we have discussed with you extensively during our previous classes, that could characterize the legal objectives of this branch of international law. And I also explained to you, as you might remember, what we call minimum standards of humanity, or fundamental standards of humanity, humanitarian considerations, which are characteristic of the vast majority of legal rules, both treaty rules and customary rules, that are comprising the modern corpus body of IHL as we know it today. All the principles, all the 5 main principles of IHL, the rules in the Geneva Convention, the rules in the Hague Peace Conventions, etc., they have all been guided since the moment of their adoption and the later subsequently application by these so-called minimum or fundamental standards of humanity and humane treatment. And of course, I don't think I have to remind you in detail that whenever we say that IHL represents a set of legal rules, we talk about rules that are binding in their nature, no matter if we are talking about a treaty rule or customary rule. Please keep that always in mind. And of course, there is an abundance of legal rules that are comprising IHL. Perhaps it's one of the most developed, structured, and also codified body of legal rules that are part of active public international law, as we know it. And of course, and maybe I should say unfortunately, but international humanitarian law remains as relevant today as before. Why that's the case? Could you please tell me, one of you, maybe Mr. John could tell us about it? Why do you think that IHL is still relevant today, before we move to the status of combatant?
Well, because regardless of all of the efforts of the international community, armed conflicts are still there.
Mm-hmm.
Or like maybe even there are more and more of them every year.
Mm-hmm. Again, reminding us that the main purposes of some international entities and the community of states aimed at preventing the occurrence of new wars in the future have probably failed. Yes, indeed. Thank you very much, Mr. John Doe. It's indeed true. Despite the significant number of IHL treaties and sources and other important rules of international law, armed conflicts have not decreased in their number, and they have also changed in the nature. Nowadays we have, as you again might remember from our first class, there is a lot of complicated armed conflicts which do not pertain to traditional classical forms of, for example, international armed conflicts. And of course the application of legal rules in such conflicts, for example Syrian conflict, which has a very mixed nature, both international, there are elements of non-international or internal armed conflict. The application of legal rules in those areas where those conflicts are happening can raise a lot of questions. So please keep that in mind, that we're talking about a branch of international law that is very, very relevant today, whether we like it or not. Thank you. So let us move to them. Yes. So now, why do we have to talk about the status of combatants at all? Would you care to just shortly try to respond to that? Why are we talking about today extensively about the status of combatants?
Well, my best guess would be because it is really important to distinguish between targets that can be targeted, so to say, and targets that cannot be harmed in any way in armed conflict. And maybe this issue, well, recalling some movies, maybe this issue is becoming more and more. Well, maybe this task is becoming harder with contemporary warfare.
It is indeed, and what you said immediately reminds us about one of the 5 key principles of international humanitarian law, and that principle is directly relevant for our today's topic. It is called a principle of distinction, and I just tried to use here a more or less simplistic explanation of this principle, according to which everybody who is involved in the armed conflict, all of those soldiers, military persons, commanders and their subordinates, everybody who is participating in military operations and using armed force, they must, it's not that they can or they wish or whatever, but they must, they are obliged under IHL to distinguish clearly between the so-called combatants, persons that's defined in international humanitarian law, and we will soon get to what do we mean by combatants, and civilians, or in other words, those who are not involved directly in a conflict. So as you can see on this particular slide, for example, I try to divide these 2 key categories into 2 main columns. The first one deals with combatants and the major pertaining issues that are relevant and flow out of the status of combatants, and the same goes for civilians in the second column. So, for example, when we talk about combatants, just to make it simple and brief, combatants could be described as members, any member of armed forces in the broadest sense, lato sensu, as we used to say. Whereas when we talk about civilians, we mean all persons other than combatants, okay, everybody else, all right, who might find themselves in a difficult situation of the armed conflict. And the combatants, as we know it from legal perspective, they are entitled to take a direct part in hostilities without negative legal consequences within the meaning of international humanitarian law. Whereas civilians are not supposed to take a direct part in hostilities. Whenever they do, if they, however, become involved somehow directly contributing to the wartime activities, they may lose their status of civilians. When we talk about rights and duties of these 2 categories of persons involved in armed conflict or not involved in armed conflict, we have to always keep in mind that combatants, first of all, have the right to take a direct part in hostilities in a legal sense. Okay? Why I'm saying a legal sense? Because the Geneva Conventions, first of all, the 4 Geneva Conventions of 1949 directly grant this right to the combatants. You might remember from the materials that I gave you very recently, among which there are also the full text of the Geneva Conventions and their additional protocols, that there are the primary articles, the initial articles of the Geneva Conventions, as well as the first additional protocol. They grant this particular right to combatants, and other than rights, they are also they carry certain legal duties, and that duty would be, for example, a key duty to comply with the direct requirements of international humanitarian law. For example, to distinguish between civilians and combatants, to treat humanely the persons which find themselves in the power of the fighting party, and so on and so forth. And of course, civilians and combatants, they differ in the scope of protection that they can count on under the current regime of international humanitarian law. For example, the combatants, they are protected by relevant rules of IHL when they do not participate or no longer participate. For example, if they have been captured, if they have fallen into the hands of the enemy. That's not a secret. Very often it might happen that in the during the fighting, when the fighting is going on between two or more belligerents, they can be the soldiers can be captured. The people who are fighting may be finding themselves in the hands of the enemy, and therefore they might be entitled to the legal status of prisoners of war, with all corresponding rights and flowing out of that status. If they are wounded, that's another example. If combatants are wounded, or if they are fighting in the sea, their ship is wrecked and they cannot participate actively anymore in hostilities, they will be protected by the relevant provisions of the Geneva Convention. For example, Geneva Convention of 1949, number 4, which is protecting a wide range of persons, including the civilians as well. Combatants are also protected against certain means and methods of warfare, even when they're fighting, for example, by relevant Hague Conventions or conventions that have been adopted in order to prohibit or restrain certain types of particularly dangerous weapons, for example. When it comes to civilians, they are entitled to protection under the Geneva Conventions because they do not participate in hostilities, and hence they do not contribute to the military effort, to military objectives, and they would be protected as civilians also in the hands of the enemy, okay? For example, in the occupied territories, and they will have to also be legally protected against attacks and negative effects of hostilities. That is something about which Geneva Conventions and their protocols are very clear about. As you have seen from the assigned analysis of articles that I have given you earlier. Okay, this is a general description of pertaining issues related to rights and protected status of combatants and civilians. There are many more issues that could have been covered, but unfortunately today we don't have time to do all of that. However, if some of these things are causing questions, if you want to clarify, you are always welcome to come to me, or we can talk about it during our next session. I will always be happy to do that. Now let us move on to the question, as I promised, of lawful and the so-called unlawful combatants. The exact provisions under the acting rules of international humanitarian law that are pertaining to what we call a lawful combatant or legitimate combatant, as they sometimes say, would be Article 4 of the Third Geneva Convention relating to the protection of the prisoners of war. And as well as the additional protocol number 1, which, as you all recall, is dealing with protection of those involved in armed conflict of a specific nature, which is international armed conflict. And there are several articles as well, which are defining who could be lawful combatants during international armed conflicts. So, as I said, lawful combatants are entitled to the status of provisions, of prisoners of war. And there are certain conditions that must be satisfied before those combatants can claim to be lawful, meaning fully legally covered by the application of the Geneva Conventions. For example, they must be acting, for example, out of these several conditions, they must be acting under a direct or indirect command of military hierarchy within the units, within the compartments of the armies that they are fighting for. They have to form a certain formal, they have to comprise of certain formal divisions or structures within the army. They have to wear uniforms, military uniforms. They have to openly use arms whenever they are resorting to the use of armed violence, armed force. And those provisions have been formulated in detail in the Hague Conventions of 1899 and 1907, but even in a more detailed way in the Geneva Conventions of 1949. Of course, today I'm not going to bore you down with recapitulating all those provisions, but of course that will be very relevant when you will be dealing with your written assignments. Of course, we have to realize always when we are talking about these things, when we try to decide cases dealing with the status of combatants, that one and the same person, one and the same subject cannot be simultaneously recognized as both a civilian and a soldier. That's a simple fact. That's a simple reality. We have to always keep that in mind, that one and the same person cannot claim to be fully entitled to the civilian status and its related protections, and at the same time to claim that he or she is a combatant and is also entitled to all the rights and protections that are afforded to combatants. Okay, so now this very infamous concept of unlawful combatants, which for the first time was used by the representatives of the United States, this is kind of a tricky issue, kind of a tricky question. First of all, why is it tricky? Because there is no legal document which would name certain categories of combatants as unlawful combatants. There is no legal source in international humanitarian law at the international level, either a treaty or a customary rule, that would designate such a title. Okay? In the conventions that I mentioned or protocols, you will not find this particular term. However, this term has been increasingly used by scholars, by lawyers, not just American lawyers, in order to designate those individuals, those persons who are involved in military, for example, who are involved in military action, let's say during the nighttime, under the cover of darkness, while pretending to be an innocent civilian by day. So from this we can extrapolate that we're talking about a negative concept, of course, and this is exactly the case when you shouldn't identify one person at the same time as both a civilian and a soldier. Okay, and why unlawful combatants? Concept of unlawful combatants is undesirable or a negative term is that because, first of all, unlawful combatants, when they become involved in pretending to be civilians, but at the same time they start directly contributing to military operations, for example, in the guerrilla war or as partisans, they may be lawfully targeted by the enemy forces. Okay, the enemy forces will not be judged if they lawfully target those persons, while those persons are actively contributing to the war effort. But at the same time, these unlawful combatants, they won't be able to claim all the privileges and rights of the lawful combatants. And at the same time, very importantly, they will no longer be able to claim the benefits of the civilians, of the civilian population, that are mentioned or listed in Article 5, the first part of the 4th Geneva Convention, probably the most famous out of all 4 Geneva Conventions of 1949, that is dedicated to the protection of civilians. So, in order to exemplify my words to you, I would like to cite here one interesting case which was decided by the United States Supreme Court already back in 1942. Please note the date, note the time, because it was the time when there was no expansively codified IHL as we know it. There were only several key Hague and Geneva treaties, but no key Geneva conventions or their additional protocols and subsequent treaty sources were in existence. Okay, so this case judged 8 German nationals, okay, in the United States who were trying to claim that they could not be considered as unlawful combatants, and they were privileged to be considered by the to be falling under the definition of additional protocol 1, articles 43, 44, and 44, and 3 and 5 as lawful combatants. And the wording of the main decision is curious. It says, lawful combatants, they are subject to capture and detention as prisoners of war by opposing military forces. This is a legitimate action. However, unlawful combatants are likewise subject to capture and detention, but additionally, they are also subject to trial and punishment by military courts, military tribunals, for the acts which render their participation in armed conflict or belligerency unlawful. This is not a very popular case, I must say in advance. It has been heavily criticized by lawyers, by significant authorities in IHL. For example, by American Bar Association, there have been certain critical points. The famous Justice Jackson, who, as you might recall from watching the movie with you earlier about the main Nuremberg tribunal, was one of the founders of this tribunal. He also indicated certain critical issues with respect to the U.S. jurisdiction in this case, and so this case is notable for several reasons. Okay, but it's relevant here because it kind of more or less accurately summarizes what we mean when we say unlawful combatants. In other words, the participants in hostilities that can be lawfully captured by the enemy, that can be detained, and that can also be subject to judicial procedures. And that are not, by the way, that are not entitled to legal privileges under IHL that should be afforded to the lawful combatants. And my last points here, because we have to soon summarize this presentation and then go to your questions. There are some things that have to be mentioned. I'm going to do it only briefly here because all of them is all of these points are each deserves as how to say, a separate long treatment, but I'm just naming them for you to be aware, and in the materials that I already gave you, you will find a very interesting analysis on all of them. For example, in the book by Nils Meltzer, Marcus Assoli, and so on, that you can find in the L drive. The question of the status of combatants, for example, becomes especially important when we talk about the so-called non-international armed conflict, or NIAC. Okay, and every time when you have to analyze, actually you might later for our first midterm, you have to keep in mind that when you have to talk about the status of combatants in internal armed conflicts or non-international armed conflicts, you have to first of all apply, when you're qualifying the conflict, the so-called Common Article 3 of the 4 Geneva Conventions of 1949, that is also commonly referred to as the Mini Convention, Mini Geneva Convention. That is the article which accords the minimum set of basic fundamental rights, okay, to the participants in non-international armed conflicts. And the famous case of 1986 of the International Court of Justice called Nicaragua case, the case which is notable for its legacy on developing international legal rules, also confirms that Common Article 3 applies first of all to non-international armed conflicts, and it contains the minimum required set of rules that has to be used whenever you try to qualify the status of combatants and the armed conflict as such. There are some rules, customary law rules, treaty rules, on how unlawful combatants should be treated. Please do not be mistaken. When I said that unlawful combatants lose their protection under IHL, lose their entitlement, for example, to the status of prisoners of war, it doesn't mean that they will not have to be covered absolutely with no legal rules. Of course, law will still continue to be applied. For example, rules of domestic legal system, a criminal law, for example. Okay, it's just what the modern international humanitarian law agrees upon is that unlawful combatants, the so-called unlawful combatants, they represent a sort of a gray area in IHL, and they cannot be entitled to the same level of treatment as lawful combatants. Prosecution of war criminals versus prosecution of unlawful combatants, there are also certain unique aspects that we have to mention here, but I'm gonna tell you only one in order to save time. When war criminals are prosecuted, they're prosecuted at the international level for the commission of one of the types of core international crimes, which would be war crimes, under individual criminal responsibility. When we talk about prosecution of unlawful combatants, as the cases in, for example, Guantanamo and other places demonstrated, first of all, they will fall under the ambit of domestic criminal law. So that's one of the key differences here between the prosecution and trial of war criminals and unlawful combatants. There are several specific subjects and categories that are regulated to a different extent in the acting international humanitarian law treaties and customary law. I just named here several of them. The list may go on. Spies, mercenaries, members of private military and security companies that can be considered lawful combatants, saboteurs, and I put a question mark on what we call terrorists. These are all have caused in due time certain questions, problematic issues, and I'm mentioning them here for you to be aware that, to summarize all what I said, to be aware that the question of division of the combatants on the battlefield, soldiers in other words, who are employing weapons and actively contributing to armed hostilities, into lawful and unlawful combatants, it remains one of the controversial issues of today's international humanitarian law, for which it is often criticized, and it raises also the question of how much of the existing legal rules under IHL still probably needs to be refined, redefined, and maybe reformulated again. So this is it for today. This has been my presentation. Now I'm open to your questions if you have any. Please, Mr. John Bell.
Thank you. I just wanted to ask if, as understood, the general rule is that a civilian loses his or her status of combatant if he or she starts participating in hostilities. So my question is it happening regardless of the state of mind to the civilian? And just to, well, maybe I'll provide an example.
Yes, please, go ahead.
I remember a computer game I was playing just recently, and although it was not about armed conflicts, I would try to tailor as much as possible. There is basically an assignment to clear the certain building from the enemy, and there are some enemies that you can shoot and kill, and there are some civilians that you cannot shoot and kill. And there was this particular woman who were considered to be a civilian. She was running around the baby, supposedly her baby. And due to the fact that suddenly she saw armed people who have entered the room, killed somebody else, she started shouting, running around. She tried to protect her baby. She took a gun and pointed at basically the player, the team. And from that moment, I think that it was possible to shoot her and kill her, and that was allowed. Even though I don't think that she was trying to take certain part in the hostility itself. She was just in shock. So does it still make her a combatant?
Before I respond to this with my own answer, can I ask you a small question? Do you know if this game scene, this situation, was based on any real cases, or it's just a game? It was just a scene in a game.
Well, in the game it was a counter-terrorist operation, not a military conflict. And the game itself is a imaginary alternative reality. I would say that I think deals with potential warfare between Russia and the United States, but I'm not sure.
Well, let's keep in mind that from time to time security forces like police may gain an exclusive mandate also to participate together with the army, together with the official armed forces in an armed conflict if they have to. Okay, in many countries the legislation allows for that in certain exceptional moments. So what you are describing, from my perspective, I think could easily happen in real life situation, whereby indicating that if it's a non-international armed conflict, for example, then the rules that I told you about, such as Common Article 3 to Geneva Conventions, may apply. Okay. Now, when it comes to the legal aspect of your question, the state of mind or the subjective side of the person in question, I don't think that acting more than rules of international humanitarian law, be it a protocol or be it later conventions, treaties, and documents which have been adopted after the Geneva Conventions, they take into account this important aspect. Well, it may be to a certain extent explained by the fact that at the time, back at the end of 1950s, these kind of complicated situations could not have been foreseen, right? Which nowadays might be reconsidered, might have to be reconsidered. What I think is that generally the rule is the moment that she takes the arm and starts shooting it against the soldiers or against the counter-terrorist forces, she will immediately qualify, in accordance with those articles that I mentioned, as a civilian, former civilian who starts actively, in other words, directly participating in hostilities, and accordingly she would lose protection. But take into account that here we're not dealing with intentions. We're not here apparently based on what you described. She is not precisely aiming at harming the enemy soldiers or the counter-terrorism forces. She is not aiming at gaining any military objective. I would say that rule, it causes certain questions as to the fairness of such qualification. So I would say it's a problematic issue which has still not been covered by the acting modern rules of international humanitarian law. Maybe there is already a need to somehow modify or amend the existing rules to also rules of IHL to also include the mens rea element, the subjective intent element of the persons whom we could consider as unlawful combatants. Would she have to be qualified as unlawful combatants? As much as I would hate to say that, but the acting law would tell you yes. Because she takes up the arms, she's using the arms, she's probably shooting and maybe even wounding the soldiers or the security forces. And that is definitely a big issue, a big topic. And of course, it also raises the question about the applicable criminal law, the criminal legal norms. So thank you very much for your excellent questions. Do we have any other questions? Okay, then I thank you for your attention. Thank you for your active contributions. We will meet again in 2 days to discuss the status of prisoners of war, which is also a very, very curious and challenging question. Thank you very much. Please stay safe and healthy. Goodbye.